Hi everyone, welcome to my channel. If this is your first time seeing my face, I am Jaleesa, your friendly neighborhood lawyer. Welcome to another episode of Alien in the Courtroom series, a series aimed at helping young entrepreneurs and business professionals and making better legal decisions for their brands. Today's video is all about patent law. I saw a photo circulating around on Twitter the other day, and it got me really excited to talk about patent law with you guys, especially patent law within the fashion industry. There's so few examples of that happening within the fashion world. But if you let social media tell it, everything is, you better patent that before Fashion Nova takes it. You better patent that before Louis Vuitton takes it. Lay people, social media, artists, creatives, designers, just people who are non-lawyers, which are referred to as lay people, use the word patent as synonymous with protection. And though that is true to an extent, to a degree, a patent is a particular and very specific type of protection that doesn't apply to a lot of situations out there. And of course, not everyone has found my channel yet, so they don't even know that they're using the words incorrectly. They might not ever even enter into a venture where they would have to use these words correctly. But we're gonna make sure that my young entrepreneurs and business professionals know how to use this word properly and know how it actually works within their business. Let's get into the video. As always, it is important that I note that these videos are intended for educational purposes only. In no way should you consider me to be your personal lawyer. And if you should have any questions that are specific to your brand, then please seek outside counsel. Just some disclaimers before we really get into this video. There are a couple things that I want the general public, entrepreneurs, to know when it comes to patent law. Firstly, patents cost money. Design patents have generally not been pursued within the fashion industry because they are often prohibitively expensive. They can cost anywhere between $6,000 to $10,000, and a lot of young artists, entrepreneurs do not have that money on hand, as you can imagine, and a lot of big designers do not find that filing for a design patent is worth the hassle. Secondly, patenting is very special, and a lot of companies, business professionals, young entrepreneurs may never actually patent anything within their business. It is so special, in fact, that to be a patent attorney, some of the people that are making really some of the big bucks within intellectual property in the entertainment field, you're required to have a science and engineering background. You need that science and engineering background in order to file for a patent for a client, and it's also required that they take an additional bar exam. So not only do they have to take the bar exam that all lawyers have to take in order to practice, but they have to take a patent bar exam. It costs a lot of money to patent things, and it costs a lot of money to hire a lawyer, because let me tell you now, a patent is not something that you can file on your own. You're going to want a patent attorney to help you file a claim. It is such a technical process. I wish I had known in undergrad that you were going to need a science engineering background in order to do patent law. I wish I knew in undergrad that fashion law or anything like this even existed. I think I just was oblivious to this whole area of law. And I think a lot of people are, because you guys are now only finding out about me. And a lot of you said that you didn't know a fashion lawyer even existed. So unfortunately, a lot of people are restricted from becoming a patent attorney later on because you don't have that science engineering background. And thirdly, I kind of mentioned this before, but it's barely recommended for you to do something like this yourself. Yes, you may have the science and engineering background, but a patent lawyer can really help you figure out if you're thinking too broadly or too narrowly about your claim. If you haven't already, please be sure to check out episode 1 of this series, where I explain the differences between trademark law, copyright law, and patent law. But just for a refresher, I'm going to insert a clip from that episode to explain what patent law is. Patent law is divided into 3 different types of patents. There are utility patents, design patents, and plant patents, which are for new species of plants, which might not be useful to anyone watching this video. Utility patent refers to protection of new and useful processes, machines, manufactures, or composition of matters, or any new and useful improvements of such. The invention must be new, useful, and non-obvious. And again, these terms can be broken down into specific definitions, but for the purposes of this video, we'll leave it as new, useful, and non-obvious. Utility patents last for 20 years from the date of filing, and they refer to what you typically think a patent is, an invention. So it's possibly everywhere around you right now in your house. It could be your dishwasher, it can be your microwave, it can be your water cooler, your cell phone, your camera lens, your Diva ring light. All of those things are possible for patent protection. They are technology based, they're a machine, and they can possibly have a unique component that was not thought of in a previous design and can obtain patent registration. So expanding on that topic, when a fashion designer will actually obtain a utility patent is when there is a new and useful invention or a new and useful and non-obvious machine, method, process, invention. Although the fashion industry utility patents aren't as common as other industries, sometimes inventions do happen and inventors will get utility patents. Some examples of this are a collapsible shoe, a wrinkle-free garment, a handbag with an interchangeable liner, something that's anti-sweat, maybe a 3D processing machine. And Nike actually has an automatic lacing system built within their shoe. So I guess the sneaker automatically laces as soon as you put your foot within it. That's really cool, and that's something worthy of a utility patent.
There's a catch, however. The sneakers can only be bought by users of the Nike Plus app. Those interested will need to sign up for an account and wait for updates. The HyperAdapt will come in 3 colors, white, gray, and black. When you step in, your heel will hit a sensor and the system will automatically tighten. Then there are 2 buttons on the side to tighten and loosen. You can adjust it until it's perfect.
Even something that would make you invisible, like the cloak in Harry Potter, or something anti-aging, as long as you wear this item, you'll never die. Oh, that was also from Harry Potter too. The guy that was wearing the, Harry Potter has some utility patents on their hands. Those are very extreme examples, but you get what I'm saying. It has to be new, useful, non-obvious in order to receive a utility patent. Design patents, on the other hand, are a lot more common within the fashion industry, and they are all about protecting unique ornamental appearances, aesthetic features of your item, of your invention. Design patents refer to the ornamentality of an object, and this is where it can kind of get a little bit blurry with copyright law, because copyrights also protect ornamentality as well. Some famous examples of design patents are the Statue of Liberty, as I stated before, the curvy shape of the Coca-Cola bottle back in 1915, ornamental designs on jewelry, automobiles, furniture, as well as packaging and fonts and computer icons. Stuff of that nature can be design patentable. So design patents make sense if you are designing handbags, shoes and footwear, jewelry, hair accessories, home decorations / decorative accessories, and that could be things such as like fine china, table settings, the back of a chair, anything like ornamentality of like furniture and home goods. Those can be examples of design patents. And just from industry standards, it is easier to obtain a design patent than it is to obtain a utility patent, but they both still take a very long time to receive. It often takes the USPTO 20 months to approve or deny a design patent application, and that is simply too slow in the fashion industry, where trends tend to move fairly quickly. Oftentimes, the design that's sought to be patented is already out of fashion by the time that the patent office issues the design patent. The USPTO does offer an expedited means of obtaining a design patent, but even then, that's 10 to 12 months to get a design patent approved. The fact that a designer can file for a patent and then not receive registration on that patent for 21 months, by that time, the designer has already 4 seasons ahead, 4 to 5 seasons ahead, and they have no interest. I think it's even more. But the designer is already far ahead and they may no longer have interest within that design patent. So a lot of times that's why fashion designers do not find that a design patent is worth the hassle, nor is it worth the money. I just went ahead and grabbed an example of a design patent from my own closet. They are the Fenty Puma creepers. Puma actually has a design patent on these creepers, meaning that no other company out there is allowed to make shoes that look any bit similar to this for 15 years, because that is how long a design patent lasts. I previously did a video all about these shoes when I first got them, and then shortly after I picked up my second pair of Puma creepers at the thrift store for only $20. So win, steal, they're definitely authentic. And this one I actually purchased, I think online, whatever. In a sense, it makes more sense to maybe have a characteristic of your shoes like the Louboutin red sole, because that red sole can be trademarked and that can last indefinitely. It will last forever as long as you continue to use the red sole on every shoe that you produce. It is possible still that Puma has a trademark on some element on this shoe. Not sure, definitely the logo, of course, but they may have something else protected about this shoe that I may not see. Maybe this swivel on the shoe, because that seems to be prevalent throughout all. So maybe they own the swivel as a trademark on that. And the way that you have to describe a design patent is so specific. You have to be careful to make sure that you put the right height or width measurements from lacing to toe. You want to make sure that you're creating or specifying elements that do not serve any function to the fact that it is a shoe, but just something that makes the shoe look good. So it's all about describing the aesthetic value of the shoe. You're describing the fact that this shoe, the sole, for example, bottom part, it has ridges on it that serves no purpose to the shoe but other than cool factor. And actually a couple of years ago, I believe, I haven't really looked into an update on this case, but Forever 21 tried to create their own version of creepers on their website, and Puma was not happy about that. So from what I remember, Puma was suing Forever 21. Not sure what came of that lawsuit, if they settled, if Forever 21 just cease and desisted. Not sure about that, but they owned this type of shoe for 15 years. So that's the difference between actually filing for a trademark for some of your designs rather than filing for a design patent. So the next time someone tells you that you should patent something, be aware that patent law may not be where you're heading. It's a lot of money, but a lot of things do not apply to patent law. You may have better luck with trademark law or maybe copyright law, but definitely trademark law may be right up your alley. That brings us to the end of this video. Give me a thumbs up if you enjoyed. Feel free to leave a comment down below if you have any questions from this video or any other questions in general, because your question can be my next video. That would help me out a lot. Definitely subscribe if you haven't already, and share this video with a fellow entrepreneur or 2 or 4 or more people. I'm trying to get this channel closer to monetization, and I am nowhere near close. So if you feel that you've gotten any value from this video or any of the other videos on my channel, please share this video or share my channel with some friends. I greatly appreciate that, and I'll talk to you guys in the next video. Bye.